Hi all, good afternoon. Hope everyone's doing great. Before we jump onto the session, I would just take 2 minutes for having a quick word about AVA network. Our core idea is simple: connect, collaborate, and succeed. We are present across multiple cities, including Pune, Bangalore, Hyderabad, NCR, Ahmedabad, Kolkata, and Surat, and more, which helps us support clients with local execution and one standard of quality. AV Network is built by ICI qualified partners with deep industry experience, including the exposure to global firms. And most importantly, we are a full stack firm. From assurance to compliance to risk advisory, finance and reporting, cross borders, business transformation, and digital transformation. So when a new regulation or a change lands, we don't just look at it in a single dimensional, but cover it via 360-degree approach, which we normally term it as covering the financial, operational, and compliance perspective. Now, diving into today's session, what I would tell you is in today's world, data is just like a currency. And like money, if it isn't protected, it can be stolen, misused, or quietly leaked in ways you don't even notice. Whether you're in a manufacturing company or a service, trading, or family business, you handle the personal data every single day. It can be customer details, employee records, vendor contracts, leads, CCTV logs, websites, inquiries. The list goes endless. And what makes this tricky is the data captured at multiple touch points in real time across the systems, the website, CRMs, WhatsApp, ERPs, payroll, attendance system, marketing tools. Many businesses run perfectly fine operations. But if we pause and ask, why are we even collecting this? Where is this stored? And who can access this? How long do we have to keep this? What happens if it gets leaked? We do not have answers for that. And that's where the gaps start showing up. With the DPDP framework now moving into implementation, including the rules just notified in this year, the organizations are expected to build privacy into day-to-day operations, not as one-time policy exercise, but a continuous one. And yes, there are financial upsides and downsides in real. The penalties can go high as in crores for certain failures like inadequate safety, security safeguards, and among others. But beyond penalties, the bigger risk is trust. Once the customers feel that their data isn't safe, it's very hard to win them back. To help us navigate this clearly, we have with us Srinidhi Srivasan, partner at Ikigai Law, who heads the firm's data practice. She advises the world's leading technology companies, startups, Indian and global industry bodies, and clients across fintech, health, education, manufacturing, e-commerce, and other sectors in navigating Indian and global data protection laws. And also is recognized as a next generation partner by leading journal, the Legal 500. Srinidhi will break this down in practical ways, what the DPDP Act means, how it changes business as usual, and what good compliances look like without killing the agility. Before we start, in case you have any questions or doubts, you may drop it in chat and we'll take them as and we progress. Over to you, ma'am.
Thank you so much for that introduction, Rohit, and good afternoon, everyone. Thank you for joining in. I think over the next hour and a half, we'll go over some of the basics of the law. A lot of you may have heard about the Data Protection Act and the rules, and it's been in the works for a while, but finally we are at a point where it's moved from just being a law on paper to having some implementation authority, as now there are rules that are notified under it, which give it some teeth, and the act has been now finally notified. I'll start with a very brief introduction of where we are in the journey, and what is the current status and timelines. Then we will speak about what the enforcement structure looks like, and then we'll go over the basics of the law and how they impact different kinds of industries and businesses, from who it applies to, what kind of data it covers, who are the entities involved, what is really consent? How do you operationalize consent? And can you collect and use employees' data? Can you collect and use customers' data? And how can you do that? What are obligations on entities? What are obligations on primarily B2B companies as well? Can you transfer data across the globe for companies that have operations or customers across the globe? And typically, what a project plan for data protection compliance would look like, for regardless of which industry you're in. So with that, maybe I'll jump in to start with what the current status is, what are the expected timelines for this law. And like Rohit said, please feel free to keep your questions coming in through the chat feature. We'll try and take them up along the way as well. Whenever there is any question related to a particular theme, happy for this to not be a monologue. So please do keep your questions coming, so we can take them up. So just if I had to just start with where we are currently, so this law, which is called the Digital Personal Data Protection Act, was enacted in August of 2023. After that, there was a bit of a window where the government was coming up and finalizing rules under this legislation, and these rules were finally published in just last month in November. Now that they are published, there are certain rules and certain provisions. There is somewhat of a staggered implementation, which means some of the administrative provisions will kick in immediately. So there is a data protection board that is going to be set up, which this is going to be the authority to whom individuals can make complaints, um, and write in and make complaints against the defaulting entities. So so basically those provisions kick in immediately, but for all other substantive provisions, companies have an 18-month window for compliance. So there is an 18-month period within which you must get your business in order. What that entails is across three levers. The first is when whatever touch points you have with personal data of individuals, and we'll of course speak in a little more depth on what personal data is, but broadly any individual's data, whether it's email address or phone number or transaction history, KYC records, any kind of identifying information about an individual is all personal data. So the first piece is all of these touch points with personal data. One has to review how you how you take consent, how you're providing a notice, what does the UI UX look like. I think a lot of us, whenever we download an app, there is that catch-all. I agree to the terms and the privacy policy, but whether that can continue or not. So if you're a B2C company, then the manner in which you collect users' consent will have to be reevaluated. Your entire user journey, whether it's offline collection, online collection, offline but digitized. So all of those will have to be evaluated, which means reviewing the UI, UX, user interface, user experience, terms, privacy notices. Even if you're a B2B organization, you may have a lot of individuals' data, your own employees, any other vendors, any other customers that you have, which has any individuals, even that would need to be evaluated and privacy notices updated. So all of that is kind of the front end. The second layer is the back end, which is evaluating at the back end how you're collecting, storing, processing, using that data, which translates into an inventory or a record, of all the data that you collect and process, reviewing your internal security safeguards, reviewing your deletion protocols and practices. A lot of companies in India hardly ever purge or delete data, but this would mean that one has to evaluate when data needs to be deleted, how long it can be retained, and so on. So this is really the bucket of getting your house in order at the back end. And the third is any third party arrangement that you have, your contracts with third parties, whether they are whether you're a B2B company, B2C company, essentially any vendor that you onboard, or if you are a vendor to somebody else, and you receive data under that contract, then negotiating and evaluating, revisiting those agreements to see what is it that you need to do Are you adequately reflecting data protection obligations under these agreements? How do you cap your liabilities and so on? So these are the three broad pieces: front end, which is all user facing journeys, workflows; second is at the back end, everything that you're doing, storing, using, inventorizing data; and the third is your third party arrangement. So that is really the overall what the law expects us to do. um, and what all this will translate into is there is a pretty stringent enforcement mechanism which is set out in the law. So there is a data protection board which will be set up. This will be a 4-member board. It's designed to be a digital office so that a lot of proceedings happen digitally, and people will be able to file complaints against defaulting companies, and it can issue penalties for breaches of the provisions of the act. Which can which and the data protection board will look at things like nature, gravity, duration of the breach, the kind of mitigating measures you took pre and post the breach, whether, how proportionate is it to the actual loss that has resulted to an individual. So the more checks you have in place, even in the instance of a breach, these factors are taken into account in deciding the quantum of penalty. And penalties can go up to 250 crore. So if you fail to take reasonable security safeguards, which results in a breach, then the penalty can go as high as 250 crore. For other instances also, there are high penalties set up. Of course, there is no other gradation given from 0 to 250. For that's kind of the highest penalty. But at the same time, the factors that I'd spoken about earlier, like what you did pre and post the breach, the mitigating measures, all of those will be taken into account to decide what the quantum of the penalty is. So that's broadly where we are and what enforcement will look like. So India is a bit late to the party. I think around the world there are several data protection laws that countries have already, notified and have been around for a while now. But each of these, as with India's law, have a few basic common themes, which underpin the entire law. So transparency, which is the idea that users should be able to know how their data is used. Purpose limitation, which is if you collect data for certain specific purposes, you can't simply add more purposes as an afterthought later on. The use has to be limited to those purposes which the individual has been communicated. Overall, this idea of data minimization, that you should collect only data that is necessary to provide a service. Storage limitation, that you should not unnecessarily hoard users data but delete it after use. And security safeguards, implementing measures to protect users data from a security tech perspective. These are common across all data protection laws and in Indian law as well, but Indian law does vary from global laws in certain key respects, and we'll go over some of the important themes in the presentation today. So I think I'll first start with applicability. Really, what is it that the law applies to? Who are the kinds of entities that the law applies to? What is the type of personal data that the law applies to? And who are the entities here? What their obligations are? So maybe we'll start with a quick question or a poll. Um, and Aditya, if I could request you to post that as well on the chat. So really the question to the group is, because you may have already heard about this law, who are the entities to which this law applies to? And we have a couple of options that are put out there. Is it just SMEs? Will it apply to just SMEs that have turnover above 40 lakh? Will it apply to startups that have fewer than 25 people, 25 employees? Will it apply only to a large enterprise processing employee personal data? Will it apply to all of these entities? Because we often get queries on, hey, we are just a startup. Do we really need to do all of this? We're a small enterprise, SME. Do we really need to do all of this? But yeah, I think the answer, as a lot of you are posting, is all of the above. It doesn't matter whether you are a 2-person company or a 1,000 employee company across global operations, the law applies to you practically the same way. There is some allowance that the government could potentially exempt certain startups, but they haven't done that so far. So really the law applies to everybody. Of course, one will have to do some kind of a risk rating for yourself to evaluate whether you can achieve 100% compliance in some way. But as far as the law is concerned, it doesn't really differentiate between small, large, global, Indian, none of that. So really, the law applies to everybody. And really even territorially, if we could move to the next slide, so where it applies to any organization that's processing data in India, whether it's an Indian entity or it's a global enterprise. Also, if there is processing that's happening in India, then the law applies to that entity, that organization, and you would have to comply with the law. Of course, it only applies to digitized data or personal data which is in digitized form. So if there are old paper records, strictly speaking, the law doesn't apply to that. But if that data, even those records, if they are intended to be digitized, which is the case with a lot of records these days, in that case, the law applies to that as well. It can also apply to processing outside India if it is done with the intention of offering any good or service to an individual in India. So it has a fairly wide ambit. There are some exceptions. So, for example, if you're an IT service provider to global entities, or if you're a GCC, a back office with some operations in India, but you're servicing only your global parent company and affiliates, and you're not processing data of foreign nationals. In those cases, there may be some exceptions that you can avail. So let's say it's an Indian back office GCC functions where it's a group services or group employee provisioning services that you provide for payroll processing and all of those. And let's say you have a French HQ and a global affiliates and employees from those countries. So if you are processing data under that intra-group kind of data sharing agreement, then Indian law won't apply, because the assumption is that the global laws would be passed down to you through those contracts. But besides that, if there is any Indian entity, Indian organization, and Indian employees, or really any other processing in India, the law applies to you in full force. There are also some exceptions around data that is made publicly available. If I've put out a blog and I've written some information about myself, that is fair because I intended to be put out in the world. Or if it is data that's been made public under a legal obligation, so land registry records, any public record which is made available as a matter of public record under some statute, that is also okay for organizations to collect and process. But for everything else, it's thought of as personal data, and if you're processing that data in India, then you will be responsible for taking care of it. Doesn't mean that one can't collect the data, it just means you have to abide by what the law is saying. Now, who are the individuals and the entities to which the data law applies? The first is the data principle, which is individuals whose data is being collected. They are called data principals under this law. The idea is that they should be able to control how their data is out there in the world, but the framing used is data principle. They are the ones who are the subjects, like their data is being collected and used. Then the two primary entities recognized in the law are data fiduciaries and data processors. Data fiduciaries are organizations that determine the purpose and means. That's the phrase that's used in the law, but it really means whoever is controlling and directing the data processing. So let's say it's an e-commerce platform and it is collecting data about their customers, their phone number, their addresses, to be able to deliver goods. Then the e-commerce entity is the data fiduciary. Similarly, in a lot of like an organization is a data fiduciary for its own employees' data, like your salary records and your bank account details and tax details, all of that. The company is the data fiduciary for that data. So all of these are, the entities which direct the data processing are the fiduciaries, versus data processors, who are only service providers who are processing data on behalf of the fiduciary. So in the e-commerce example, while the e-commerce company is the data fiduciary, if there is a delivery agent that they onboard, and they share the address of the individual, of the customer, with the delivery agent for being able to deliver goods to the customer. The delivery agent is merely processing the data on behalf of the data fiduciary. So they are only data processors. So similarly, cloud storage providers, let's say background verification service providers, many other entities which are only not determining or controlling the data processing, or not using the data for their own purposes, but are only discharging what their enterprise customer is telling them. A lot of B2B SaaS platforms become data processors. So this is a very key distinction in the law, because all the obligations under the law are placed on data fiduciaries, who are the entities that call shots with respect to the data, and they then must instruct. There are no obligations on data processors, so data fiduciaries must then instruct data processors to must instruct how the data processors will collect and use that data, must tell data processors, don't use this for any other purpose. In case of any breach, let us know. So this is typically done through contracts between the two. There is another class of entities known as significant data fiduciaries, which are large organizations which process large volumes of data, or there is a lot of sensitive data that they process. But these are entities that will be designated or notified by the Indian government. Once they do that, only then this becomes relevant, and there are some heightened obligations on significant data fiduciaries, like you have to appoint a data protection officer who is resident in India. You have to conduct data protection impact assessments. But yeah, that notification has not come through yet. But whenever it does, I think these heightened obligations, these significant data fiduciaries will have to also abide by. Mostly it's likely to be your large B2C companies that have a large volume of data that they process, but it could also be other regulated entities, let's say fintech companies that may be processing payments or lending. So one will have to keep an eye out for that notification to come through. So that is on what kind of processing the law applies to, who are the entities involved. Now the next theme is on what is personal data really. I've been saying personal data a lot, but personal data really is just any data about an individual who is identifiable by such data. So your pure play identifiers like name and Aadhaar and mobile number and PAN, or financial information, transaction records, SMS history, photos, all of that is very clearly personal data. But there may also be other data, for example, your transaction records, or data which may not be directly identifiable to an individual, but your IP addresses, and with other data points, one may become identifiable from that data, like number of transactions in a month. All of that, if it relates to a particular individual, it's all personal data. What is not covered though is non-personal data, which is business data, company data, anonymized records, which may be like your company PAN, TAN, GST, company, other transaction details, presentations about growth plans, strategy. All of those are also protected, but more under your trade secrets, business confidential information, those laws. This law is more interested in individuals. Corporate data a lot of times may also have personal data about individuals, like even business contact information is personal data. Your shareholders information, investors information is personal data, nonetheless, under the law. So there may be a lot of data that is mixed and mingled. So one will have to first do that inventarization to identify out of a lot of mixed data sets also what exactly is it that is personal, and that's not personal. There may be a lot of other data, for example, your just completely data that was never personal, like company information, but there may also be data that was personal data at one point but now has become anonymized. For example, an aggregated inference that people in this area are more likely to purchase a certain kind of bag, like people in Defense Colony in New Delhi are likely to respond to a promotional message on a Saturday. So those kind of aggregated inferences which are not related or linked to an individual, those all are considered outside of the realm of personal data. But anything else, anything which is saying about a particular individual, like Srinidhi likes a certain kind of bag, all of those are inferences or personal data. We have another quick poll that we'll just put up. So out of all of these data sets, which of these would fall within the scope of the DPDP Act? And Aditya, if we could have that question on the chat for people to respond. So let's say there's a handwritten visitors register, um, or there are digitized KYC records. There is anonymous website traffic stats or company financial statements. Just if you all could weigh in there, and yeah, I think most of your responding saying is, of course, digitized customer KYC records. So even handwritten visitors registers, if they are intended to be digitized, we see a lot of times that there are those security registers whenever we enter buildings that people write into. Now that is being done often because ISO standards dictate that we do that. But for those also, if they're intended to be digitized, the moment that happens, they would become personal data under the scope of the law. But otherwise, they are not. But if it's visitors entry, which is more sophisticated these days, there is a picture taken, there's an OTP, all of that is very much personal data. Anonymous website traffic stats are not personal data, but if it is a stat related to a particular IP address, it is personal data. Company financial statements, broadly not personal data, but if it has details about individuals, it may become personal data. But yeah, out of these, the one that's most clearly personal data is your customized KYC records. So that's just briefly on who the law applies to, what kind of data, and what kind of processing. I'll pause for a minute and see, Rohit, if there are any questions on the chat. That I think there was one question that had come up. Yeah.
There's one question which had come up. So the participant is asking, are the browsing history of the laptops being considered cured?
Yeah.
So there are a lot of laptops provided by the companies to the employees, and the security is of the company. So if anything is browsed there, and the internet history would be considered under this app.
Yeah. So yes, while the laptop and the device may be provided by the company, but if it is tagged to a specific employee, like this person, there will be some noting of that happening, and a particular employee is assigned that device, and there all of that history will be associated with that particular employee. It is personal data. Doesn't mean one can't track that, and I think this is going to be one of those contentious issues, because under the law, there is a question. Under the law, there is an exception for consent for employment purposes, so you can process employees data for employment purposes, but to what extent can you use that, will still be relevant. But it is personal data, so one still has to think about that as a constituent of all of the data that you're collecting.
Okay.
Yeah. Okay. And I think there was one follow-up, that it's sort of, if it's linked to one's mobile, is it still
Yeah.
personal data? I think it's still personal data. Mobile is also now, a stand-in for an identifier almost. It's linked to a particular individual. And it is typically intended to, let's say, deliver some ad or deliver something to an identifiable individual. It is personal data. Similarly, when IP addresses globally are considered to be personal data. So very likely that India may take a similar view, but the test, really, the threshold is if it can trace back to an identifiable individual. It doesn't need to be identifiable just by name. So in that case, it is personal data. And I think on the laptop question, even if it is company property, it may be company property. You're not supposed to like surf your own browsing history, your own things. But if it's related to an individual, it is still thought of as personal data. Again, doesn't mean that one can't use that data. that the company cannot surveil or can't check what the employee is browsing, because that can be laid down clearly in the company policy, but it is still thought of as personal data. Okay, great. Maybe with that, I'll move to the next theme, which is now that once you establish what is the data, what it's who it relates to, what are the entities, what is territorial applicability. Now, how can you actually collect and use the data? So there are two ways. Any data that one collects has to have some appropriate legal basis for it under the law. The first basis that is set out for processing is notice and consent, that you give individuals a notice and then you collect their consent, which is specific, informed, unambiguous, and clear. Or you justify the processing under one of the 9 legitimate uses that are prescribed in the law. And I'll speak about that in a moment. But maybe to start with, what really is notice and consent. So the law says that you must, whenever you're processing data, you have to give individuals a notice would mean you give them a list, an itemized list of all the data that is going to be collected and what the purpose of that collection is. So it will be a listing of all of the attributes of data that you collect. It has to be an itemized description. You have to tell them what you're collecting it for. So let's say in the e-commerce context, if it is personal data about an individual, like your name, phone number at the time of sign up, then you have to specify that that's the reason why we're collecting it. If it's for delivery, you collect their address and saved history, even preferences to personalize the feed. All of that will have to be set out in that privacy notice. You must also tell individuals how they can exercise their rights under the law, how they can complain to the board whenever it is set up, and the notice users should also be given the option to access the notice in English and in local languages. So that is also a requirement. And once this is shown to an individual, then their consent needs to be taken to this. The consent needs to be free and specific and informed and unambiguous. There has to be some clear affirmative action, something that the user does. It can't just be inferred by their actions, and they should be given the right to withdraw that consent also at any time, after which you stop processing. Um, and the rules add some more details to what the notice should contain, which is that it has to be understandable independently of other information. It has to have a fair account of the details, an itemized description of the data, specific description of the services. You have to give them a link to allow users to withdraw consent and so on, which would mean simply linking the terms of use privacy policies may not work. It would mean setting out more details in the workflow. So let's say if you're onboarding vendors, and some of them are individuals as well, in that KYC kind of onboarding process itself, we may need to add some means and let them know that this is the vendor contact data that we have. This is the reason what we'll use it for. We may share it for regulatory purposes. We keep it for such and such time. This is the contact if you want to exercise your rights. This is how you can complain to the board. All of these details will also have to be set out in that notice for organizations. So that's the first way in which data can be collected and processed, which is by giving users a notice and taking their consent. The second is that you justify that use within one of the 9 legitimate uses which are enshrined in the law, which includes the user providing the data for a specified purpose. So if I walk into a restaurant and I give my number for table booking, that data can be used for that without any more, much more being done. But if the restaurant wants to use that data to send me offers or promotions, then they would have to rely on consent unless it's obvious in that given circumstance. So there are some exceptional circumstances like complying with a court order or processing data during an epidemic, measures in a disaster. But the ones that are most relevant for organizations are when the user voluntarily provides their data for a specified purpose, and also employment purpose. So if a user is an employee, the law recognizes that it doesn't make sense to collect their consent as such, because a lot of that data can't be hinged on consent. The user can't be given the choice to say, no, I won't give my bank account details for processing salary, or no, I won't go undergo this background verification. So in the employee context, consent is not really appropriate. So the law recognizes this employment purpose. So let's say you collect employees' data for processing their pay, or for legal compliances. There are many different, Shops and Establishments Act, all of the wages related laws, Factories Act have many record retention requirements. Registers have to be maintained around attendance, leave, bonus, benefits, salaries, etc. For those reasons, you can collect and retain that data, even if it is actually not required under law. You can retain data for employment purposes. You could run all the data that you retain for after having run background checks, you could justify it under employment purpose. Data that, CCTV, if it's in a factory and you have CCTVs at different points to monitor what's happening, or you have attendance records, all of that can be justified under employment purpose. But even there, even for employees, it is advisable to do a data mapping to see if there are any data points that are actually not relevant. So my favorite example of this is, globally there was, H&M had been handed down a pretty hefty fine by one of the European regulators because they were collecting so much data about employees, from when they fell ill, health records they were keeping for a long time, where they went on vacation, their religious beliefs, political beliefs. So, all of that was considered unnecessary. And a similar test we'd have to apply even in India on whether this is for an employment purpose or if it is something more, and be able to justify that. So that is an important legal basis for us to bear in mind when it comes to employees' data. But yes, broadly, the way to process data is justified under notice or under and consent, or find the appropriate legal basis in one of these 9 legal bases under the law. And we get a lot of questions around employees' data, whether this can be done or not. Um, I think even, candidates data. So when one applies to be part of an organization and you run a background check, does that mean we have to take people's consent? So in that case, we often recommend that, in that process of recruitment, there should be one candidate privacy notice that is shown to the users. We create one and we include that in our onboarding process, and we tell individuals that if you're applying to us, then you will mandatorily undergo a background check at the time of as part of our employment formalities, and we retain that data for such and such time. You may even be able to retain rejected candidates data because you'd want to keep that background check report, or whatever interviews they may have done with you in the past, those records you'd like to maintain. So it's best to let individuals know that that's what's happening. And it's an informed decision that they make then to go ahead with the interview process and continue to work with the organization. There can be many layers to it. For example, if meetings are recorded, let's say there are internal team meetings and those are recorded and they are used for performance appraisal or whatever, just all of that data would still need to be identified, even for employees. While nothing is stopping you from collecting those, but we do need to make that check and make sure that all of this is still reflected in a notice. So we need to start adding some kind of an employee privacy notice as well, that users can see and accept, which is part of your onboarding documentation for all incoming employees. So that's really the basis of the law, where you either rely on notice and consent, or you rely on one of these legitimate users under the law to collect and process data. And then once you have done that, there are several obligations under the law that organizations, mainly data fiduciaries, have. The first one there is that you the overall responsibility of compliance. Maybe we could move to the next slide, so that this one I'll come back to children. So overall responsibility for compliance must be with the data fiduciary. So in the examples that, let's say we take an HR example, that you have an HRMS software, a third-party vendor for or managing all HR related functions, or even just for leave or processing pay. So you are the data fiduciary there, and this third party is the data processor. But even there, if there is a breach at the third party, the processor's end, your neck is still on the line. So all data fiduciaries, neck is always on the line. They are the ones that the individual will proceed against in case of any breach or non-compliance, even by the third party. So it becomes very important that whenever you're engaging a vendor or a service provider, you do that only under a proper contract, which also has data protection clauses, which says what they can and can't do with that data, which limits how they can use and process, and whatever they do with the data is only to service you better. So all of that would have to be baked in into the agreement. Even before onboarding the service provider, we would have to run a check to make sure some kind of a risk assessment that that vendor is okay, their data hygiene practices are kosher. That, let's say, we ask them questions around, have you suffered a breach in the past, and if you have, then what is it really that you did to help out and remedy the breach. So all of these must be baked in the onboarding process, in the contract, and even post facto, retaining the right to audit those vendors and so on. There is another requirement broadly in the law to implement organizational and technical measures to comply with the act, which is across multiple layers. So one is at a people level, that you must make sure that you are appointing the right kind of people. You make sure that you have the right kind of processes. Then you make sure that you have the right kind of technical and security measures as well. So one of those is set out in the law itself, that you implement reasonable security safeguards to protect the data. And there is some level of detailing in the rules, which is that you have to make sure that these are the minimum 6-7 requirements that are set out. So that you have some level of encryption, masking, whatever it is. You have access control. So this means that, let's say, it's the HR team does not need to have access to the CRM software. Vice versa as well. Marketing sales team don't need access to the HRMS admin dashboard. So those kind of access controls also one will have to evaluate. Look at if you're able to detect unauthorized access. Keep data backups in case of a compromise. Retain these logs whenever there's an incident for a year at least, and make sure you include all of these covenants in the contracts with data processors. So practically, this means reviewing existing safety measures. A lot of these are largely aligned with the ISO 27001 standard, but also making sure that your vendors and third parties that you work with are doing those, updating the agreements with them to make sure that they do this as well. Similarly, another important obligation under the law is around breach notification. So if you are the law has fairly stringent provisions on breaches. So which say that in case there is a data breach, then the company must immediately report first to the board, the data protection board that is set up. There is a tiered notification that immediately on becoming aware of a breach, you notify the board, and then within 72 hours, you file a more detailed final report with what were the facts, what are the remedial measures. A lot of times 72 hours is a very, very short timeline. In actual ransomware scenarios, it can take a long time to really go ahead with this and find out the root cause and all of that. But the law just sets out this benchmark. The data protection board may allow you some leeway if you tell them that, we need a little more time. But at least that immediate notification has to go. But the more concerning thing is that immediately, along with also notifying the board, you also have to notify individuals, letting them know that there is a breach that has occurred. What are the potential consequences to them? What are the mitigation measures that they could potentially adopt? So, typically this could be in the form of an email, or if it is an app-based service, then letting them know through that mechanism. But what we often see is an email that goes to the users saying, hey, there was a security incident that we suffered. We are aware that your data may also have been compromised. We tell them what was the data that was compromised. We tell them what are the measures we are taking, which is that we are constantly in touch with law enforcement agencies and CERT and other authorities for it. We tell them what are the measures we have taken, like we've logged you out of your accounts or we've upgraded our security protocol, whatever it might be. And if there is something that the individual can do as a remedial measures, that is create a fresh password, or if you've used this same password in other apps or other places as well, then reset those. So those kind of measures we'd have to send. The interesting thing is there is no risk threshold. So anything which is a breach needs to be reported to individuals as such. So that is definitely something to bear in mind here. And this would mean updating your internal response protocols, having a data breach notification policy in place to align with this structure, having internal workflows in place to really report to the board, report to CERT, and in many cases for regulated industries and sectors also report to CERT, the security, cybersecurity, emergency response team in India. And some of you may be familiar, there is already a certain direction which requires reporting within 6 hours of many security incidents. So this is an addition to that. So making sure that all of this is in place, which means having a policy and a protocol in place. That's another key measure. The other measures that data fiduciaries have to adopt are setting up grievance redressal mechanisms. So individuals should be able to write into the company and ask for clarity on when their grievances will be resolved. Similarly, even for responding to user rights, there should be some mechanism that is provided, and you'll have to publish the timelines as to when you'll be able to respond to them. Then there is a requirement to erase data once the processing activity is complete. Um, so there are some other requirements, which means that for each category of data, you'll have to evaluate whether that data is live, or um, whether there is any real need for that data anymore. So we get a lot of queries again around, let's say, past employees' data, or even users' data, whether those can be kept on file. I think while the law requires deletion after a certain point, it has some flexibility on when you can delete and when you're required to delete data. It's better to err on the side of caution, especially when there is an ongoing relationship, or even there has been a relationship like an employee-employer relationship, because let's say even for tax purposes, you'll need to retain some data for at least 6 years from the assessment year. Similarly, for a lot of other information, wages, registers, and all, you may even be okay preserving them permanently. So retention is okay, but it has to be justified either under a law, or it is required for you to be able to enforce your legal rights and claims. So that's something that all organizations will have to evaluate and think through. And when it comes to children's data, if there are some requirements in the law around processing children's data, because this is considered a vulnerable group or vulnerable section of society. So if you are processing data about kids, then it's important that you get parents' verifiable consent for that. And if even with that consent, if you collect and process children's data, you should not be targeting them, or you should not be doing any behavioral monitoring or targeted advertising to the children. There are some narrow exceptions that the government has provided, but those are for educational institutions or for health screening and certain pockets of law. But this is broadly because a lot of businesses may also have direct interaction with children who are a large user base. But companies will first need to stop and age gate and ask for some parental consent before they process a child's data. Now, for those organizations which are designated as significant data fiduciaries, I think in the beginning we had discussed that there may be a class of entities which is considered significant enough that there are heightened obligations around those. there are three heightened obligations. One is that you must appoint a data protection officer who is based in India, which means and it's a sufficiently senior person, because it says the person has to be responsible to the board directly. They must be your regulatory kind of liaison for the organization. The second is you will have to conduct periodic data audits. These have to be done on an annual basis. And they are kind of, you appoint these data auditors who are responsible to evaluate compliance with the act. You also do impact assessments, which is DPIAs, which is that you assess and manage how you are thinking about risks to individuals from data processing. Um, and the next theme that I want to touch upon is for a lot of B2B companies, which are service providers to other organizations. While the law doesn't spell out specific obligations on data processors, there are no specific penalties also on them, but that means that the contract between the data fiduciary and the processor becomes very critical. And typically, the clauses that one needs to include in the data fiduciary in any third party relationship are that you recognize each party's role. I'm a data fiduciary, you're a data processor. So this is the defined data processing activity that we are requiring you to conduct, and this is the level of security control that is required. This is your liability in case of a security incident. If there is an incident, then you must notify the data fiduciary. If you appoint any subcontractor, you must notify us. You must conduct an audit of your operations. You must delete personal data from your systems upon instruction on completion of contract. You must help us in responding to data principals requests. And also supervisory authorities must have indemnities. That's the most critical, that in case we suffer any breach because of the third party's action, then we are indemnified from it. And from the data processor's perspective, similar clauses that you'll ask for um, from the company. And I think so that's also on the different parties that you engage with. There are also some rights that are provided for under the law, which is your right to an individual's right to access information, to seek correction of their data, to grievance redressal, seek nomination, that I be able to nominate somebody else in case of death or incapacity, and so on. So it's the organization's responsibility to make sure that individuals are able to exercise these rights on the other end. I'll pause to see if there are any questions. Rohit, if you have any questions, or the group, I am also mindful of time.
Uh, Not currently, but since we have covered the applicability and consent part, let's just say there are a lot of apps where we, without reading the terms and conditions, we just click the checkbox where it just mentions by using this app, you agree we can use your data for improving services and sharing with partners. Will that be okay in this act? Or there'll need to be the specific data requirements or the purpose to be specified?
Yeah. So the law does require that there has to be an itemized description of the data, and also link the purpose to that data, and exactly what it will be used for. So I think the days of having catch-all privacy notices, we are expecting to see a lot of changes in how apps are providing these notices. Already you might be seeing in some places there are statements at least that come up that this data will be preserved with us, or this is used for such and such purpose. Or if phone book is tagged, then the reason for that. So we do expect a lot of changes to UIs, and we work with a lot of companies also to kind of make that happen, that these are the changes that you will need, this is the kind of pop-up that you will need. Even if it's a privacy policy that you're displaying, then you'll have to have a proper table saying this type of data used for sign up, this type of data used for compliance with legal purposes. So we expect a lot more detailing there. Of course, from a product lens, it's not the most desirable, because there will be more and more text, and apps might not look as nice. But I think that's the challenge, where product and legal teams will have to work closely to kind of make that work.
Okay. Anyone has any queries or questions, you can drop in the chat, please. Till then, we can continue ahead. If there's anything, we'll take it.
Sure, sure. Okay, so I think there are a couple of other provisions in the law. So one is around cross-border data transfers. This also we get a lot of queries, especially from companies that may have customers or clients or users across the globe. So while you can transfer data outside India, the government may come up with a list, like a blacklist of countries to whom data can't be transferred. They haven't done that yet, but they may in the course of the next couple of months, years, whenever the law is actually operate fully in force, and say that for certain countries there are these additional conditions that we'll have to be mindful of. There are already sectoral regulations, like RBI has sector specific norms around payment data, around lending data, that those have to be localized. Those will continue to prevail, but broadly, this is a more generic enabling provision that you can transfer data outside India, but there may be more harmonization in the future. So I think a lot of clients ask us whether it's okay to have offshore vendors, and I think while it's okay because it's not currently a blocker in the law, but I think there may be some risks depending on where that vendor is located. And at the very least, it's important to bear in mind and to keep track of these notifications, where of if any country is being notified in this blacklist. The other theme in the law, which is interesting and a bit different, is around consent managers. The idea here is that there will be these single point of contact entities which will get registered with the Data Protection Board. And these entities kind of sit between the individuals and the data fiduciaries to help manage and review and withdraw individuals' consent. These are yet to be brought in force. Now, when the first the board has to be set up, and then these consent managers will apply with the board and get registered. But the idea is, let's say if I've given my consent at some point to a telemedicine app, a streaming platform, and an e-commerce platform, that I have one dashboard where I'm able to see all of these consents and manually, review them. That is the functionality that the consent manager provides. And there are some terms specified. So the consent manager cannot become its own. They can't start using the data for their own purposes. It must all be interoperable. So some of you might be familiar with the account aggregator framework, under RBI norms, for where there is financial information, users and providers. So it may be similar to that, where there is an intermediate entity which doesn't use the data for its own purposes, but it's kind of providing a service to individuals, um, for this purpose. So right now, though, it's voluntary to integrate with these consent managers, and I think we'll see some maturity come in the market as these get notified as well, and registered, and then there may be options for users to use it. Now, I just want to also briefly go over what typically the whole compliance exercise is going to look like for companies. To start with is the process called data discovery or inventorization, where we try and gain visibility into data handling practices across different teams. For this, there are usually these data record sheets or questionnaires, which one has to sit with each of the teams and say, here is what your data, here is what we are collecting the data for, here is an internal data life cycle. And we schedule conversations with each team to understand how they are collecting data, be it HR, be it IT, finance, and there may be overlaps, like the same data is used by different teams as well. So, but really the first step is to look at your structured, unstructured databases and see how data is being collected, and processed. Then the next step is to conduct a gap assessment about how the organization as a whole and each team is collecting and using data in accordance with the act and rules. So this is sort of mirroring what we had earlier discussed about front end, back end, and contracts, that each of these elements we review and say where you are under these heads, and how you are faring under those. And then based on that, there is a roadmap of compliance, a gap assessment report, or a roadmap of compliance, and data protection addendums, a contract playbook that one can create. for this. And then the next step is drafting these documents and policies. So we create these. There are a lot of documents to be made. Your privacy policy, cookie notice, policy for data retention, policy for responding to user requests, breach response policy, employee privacy notice, handbook. So we start updating those. There are still some, while the rules are out, there may be some specifics which still need to be added, like once the data protection board is set up. So one also has to add how you can complain to the board in the notices. So once that is enforced, that will also have to be reflected here. But by and large, we kind of update all of these policies within this window that one has for compliance. So that's really the project plan as well. On we start with inventorization, knowing your data across teams, across functions, identifying what is personal data, what is in scope, what is not in scope, then identifying the gaps from a front end perspective, at the back end, and from a third party contractual perspective, and then drafting the policies and playbooks that are required to fill those gaps. With that, I think I'll conclude the presentation part of this discussion, and happy to take um, any questions that the group has.
Thanks. There was one question. Are the penalties triggered only when the individual suffers measurable harm or the regulator imposes fines, or without even providing the individual loss? So if there's no uh, measurable damage, will the penalties be triggered there also? And even if the data is not misused?
Yeah, great question. So actually, under the law, any non-compliance can trigger a penalty, which is, it's essentially, it doesn't matter whether the individual has suffered any tangible financial loss or other loss. Any non-compliance can result in a penalty. So it's not important that there be loss. But if there is some tangible loss, that may result in a higher penalty. That is one of the factors that is listed in the adjudication of how penalties are awarded. But as such, even a simpliciter non-compliance could result in a penalty. If there is loss to individual, then quantum may be higher.
Okay. And again, I suppose we have already answered, but if you would like to cover it again, is there any threshold limit or above on which the companies this act is applicable to?
No threshold. All organizations have to abide by this. Even if you're a two-person company, one has to comply. Of course, one will have to weigh the risks. Let's say if you're primarily B2B, in the line of fire, I think it will be large organizations which process large volumes of data, but any user data, or have a large employee base, or there are specific sensitive categories of data, they are at higher risk. But doesn't mean anyone really could be in the firing line, because the law applies to everybody.
Okay. Any participants would like to ask questions, they can switch on their mic and ask.
I think Deepak has a question.
There's one, yeah.
Yeah.
There's one question related to what would be the technical tech department's role in this act? What would there be any changes? What they have to do?
Yeah. So IT teams have a major role to play. One, because even if I'm understanding the question correctly, that it's about different teams, the IT function, product, tech folks, what is it that they need to do? One is just all kind of, they actually play a role throughout, because they are the ones who will know where the data is stored. What are the kinds of internal, external applications that you have? You may have a structured database for customers, so a CRM software, but you may have email, which anyone can access outside of company devices. So they do play a major role in helping understand and discover the data, and also specific security safeguards that are set out, that you have to, those 6 7 that we had listed, that you need to maintain a record of the logs, maintain logs for a year. So all of that is also something that the tech teams will be closely involved in. Actually, legal will only set the protocols and the processes, but a lot of the implementation may need to be done by tech teams. So it's one of those that is cross-disciplinary, like all different participants and teams will need to be involved in this entire process.
Okay. Anyone else has a question? You can raise your hand and we'll allow the mic. There's one question, Srinidhi, that how can AI help you?
Yeah. So I think like with any other function, AI can assist with. So I think the places where we are seeing AI work is so these data discovery exercises. Now it can be an Excel sheet where you're mapping out basics of what is the data that you collect, where you're relying on, the teams to tell you. But there are also some tools in the market. I will say they are expensive though, so it really depends on budgets and how much one wants to invest in compliance. But discovery essentially is that there will be these tools that can be integrated with your different structured and unstructured databases and applications. And then they automatically kind of identify what all other attributes of personal data that you're collecting. We are seeing a lot more involvement of AI there, even in the compliance process. So perhaps that's one place where we see some automation. But yeah, I think it's still cost is a big consideration, at least in all of our conversations often with clients. It's so one may want to apportion also how much do we want to invest in this year, next year, what is our scale, and depending on that, embed and figure where AI can really come in and help with some automation.
Also, with related to this, AIs are being used by a lot of firms and also the firms like us. How would that help us where we are or protect us where we'll be using the client's data to analyze something for audits or sampling? Do we need to safeguard ourselves somewhere?
Yeah. That is a big piece. So any AI platform will be your data processor. So if I service a client, and to be able to service them better, I use an AI platform, and there is a breach there, and it involves personal data, then my neck is on the line. I'll have to be able to justify that I put in place enough measures and checks and balances and because the law puts the onus of compliance and penalties around breaches on the data fiduciary. And these platforms will be data processors. So I must then make sure that there are enough checks that I'm putting in place. That's why often when we're also either you have bespoke AI models for your organization, which don't which provide like segregated data sets and don't travel that data back to the larger platform. So those things will become a lot more, one will have to be a lot more careful. At least right now, when it's about client environment and client data, we think about it more from the perspective of, let's say, trade secrets or IP. But if it involves personal data, then we'll also have to think about this law. And if we're using AI like any other tech, like any other data fiduciary, the same rules apply to AI models as well. So notice, consent, all of that really applies. It's tech neutral. So whatever processing we are doing, it applies to that in its entirety. So that is an assessment that we'll have to bake into our compliance program.
Okay. Anyone else has a question? We can take it or we can wrap up the session. So there's a follow-up where how are the corporates and the companies currently taking these new law? What are the actions they are taking on?
Yeah. So so the steps they're taking is the three-part kind of project plan, and a lot of them are in that inventorization phase, which is evaluating exactly what is the data that they collect and process, and also understanding priorities. Let's say if you're a B2C organization, you would prioritize your user-facing platforms first, and then gradually you will come to your own employees and getting your house in order. So a lot of them are in that inventorization phase, of really understanding and evaluating what is it strategically that one has to do, what to start with, what are the first steps, what is the data that they're collecting. I think a lot of organizations had become familiar with this law because it has been in the works for some 5-6 years now, and every year there was conversation that it'll come this year, it'll come this year. Now it's finally come. So people have some familiarity around it. A lot of the global companies already have these processes and protocols, so they are evaluating what is the delta in Indian law, what are the differences in Indian law, so that they can just plug in those gaps. So that's how different companies are approaching this currently.
Great. So, sure. We'll wrap it up. Thank you. This. So, thank you, Srinidhi, for the clear and practical walkthrough of this act. We have covered almost everything. We have covered a lot of important ground where the core principles come in for the data protection to the practical steps needed for the compliance. It's clear that this act is more than just following the law. It also talks about taking the ownership of how we manage and ensure that the data is handled with necessary care and responsibility. Thanks again for everyone for being this part of the session. I hope you leave with a better understanding of the act and how it applies in principle in our day-to-day work. And also, to understand the new labor code, we have got a webinar scheduled on 23rd of December. That's next Tuesday at 3 p.m. We'll be dropping a link for easy reference. And thanks again, Srinidhi, for your time.
Thank you so much. Thanks so much, everyone. Bye bye.